Ladies and gentlemen, very welcome to this conference, this symposium celebrating 10 years of the Transnational Program. We are very honored to have as a keynote speaker Professor Sabino Cassese. So already thank you very much for coming and joining us. And so we can basically learn from you about democracy. So thank you. But before we start with the actual program, we have three speakers introducing the symposium. And the program says Fulvio Cortese as first speaker, but unfortunately he could not come. But the Dean will be represented by Professor Antonioli, who will come forward in a minute. Then Andrea De Bertolini, who will speak on behalf of the Trento Bar Association. And then Sara Giacomini, a PhD researcher at this university, who will speak from the perspective of the students. There will be very short introductory opening words, and the first is Professor Antonioli. The floor is yours.
Well, first of all, I apologize for Fulvio Cortese, who's currently in a roundtable that is taking place here at the faculty, so unfortunately we still don't manage. We do a lot of things, but not to be simultaneously in two places. So I'm here as the Vice Dean of the faculty, and it's really a great pleasure to be here. First of all, because there are a lot of friends that are around. Let me just first mention the two previous deans, which are sitting there, Pepe Nesi, whose mandate has just run out, and particularly also Professor Tognati, who has been actually the engine, because the starting point for this enterprise has been 10 years of the TLP program, and Dean Tognati, as he was really a strong engine for everything that has connected to the internationalization of the faculty, not just in terms of staff, but also of students. So I think that we are very happy to have you here, because he's the history of this faculty. Then let me mention Elena, because Elena Giurati has been not just organizing this moment, very important moment, but she's also been one of the important mechanisms in this whole procedure. And it has been a challenge, because when the thing has been started, it was quite a complex program. It required a lot of work in terms of organization, in finding out whether this would have been compatible with our system. So it was really a kind of bet on whether the mechanism would have been successful and whether the student would have believed in that kind of thing. And in fact, it turned out to be a big success. It was a lot of work, but students were very interested in the enterprise. They had very good results. Work with partners has been very effective, and somehow this has been shown as a good example on how very complex and difficult programs could actually work out. And I'm also very happy that a lot of students are around today, because I think that's the most important component. There's a lot of machinery to be built around these kind of programs, but actually it works if the students believe in it. And I think that's a good example on how this kind of work is going to produce positive results. And I think it's going to be a good example for future cooperation that the faculty might have. Then, of course, we have friends that have been knowing the faculty for a very long time. Just let me mention Professor Van Erp, who's been teaching here as a visiting scholar for many, many times, and is now also cooperating in the newly established 3-year course program, bachelor program in English. Then we have Professor De Vries, who has been also cooperating. We have Professor Coby, that is a partner for a TLP, and of course we have the great privilege of having Professor Cassese. So I think that's a very good occasion for, Ellen will tell us what has been done on the TLP, but also to have a broader framework about what it means to try and have a truly globalized legal education, which is something that we've been speaking for a long time. But of course, when you have to move down from the theoretical analysis into actually defining what it takes in order to produce lawyers that are capable of working in a globalized legal environment, you need to have a very comprehensive view. And I think that's an excellent occasion for doing that. So thank you to everybody for being here, our guests, our colleagues, and our students. Thank you very much.
Buonasera a tutti. Velocissimo anch'io, però sono veramente contento di poter essere qui e mi aiuterà a tradurre in inglese questi saluti. Voi capite che la mia età anagrafica mi ha portato quasi inevitabilmente a non poter parlare in inglese. Questo davvero è un problema che io oggi sento con grande sofferenza, e tuttavia ci tenevo a portare i saluti dell'Ordine degli Avvocati di Trento in questo contesto. Elena Ioriatti è stata veramente gentile nel coinvolgermi e il piacere mio è dato dal fatto che io ho studiato in questa facoltà. Ci sono qui alcuni miei professori dai quali io ho imparato non solo il diritto ma anche un modo di essere, un modo di credere nelle cose, per cui essere qui oggi per me è davvero importante.
So, good evening to everyone. I'm very happy and honored to be here, and I'm helping him translate. And this event and this project is particularly important, and I care about it much because I studied here, and I've been working here as a lawyer, so it really means a lot. I want to thank Professor Ioriatti and all the professors who were able to build this project.
Ci sono poi altre cose che mi rendono questo momento particolarmente piacevole. Il primo è dato dal fatto che l'Università di Trento, e lo possiamo dire, è giusto che venga riconosciuto, è una delle eccellenze, la Facoltà di Giurisprudenza, una delle eccellenze di questo Paese. E i dati, i report che annualmente ci vengono consegnati non lasciano equivoci di sorta. Questa è una facoltà dove credo che davvero si formino dei giuristi, e questo è il secondo elemento di mio personale piacere.
This is a particularly pleasant moment also because I am and we are particularly proud of the University, of the Law Faculty of the University of Trento, because it is, as we know, one of the really most excellent universities in Italy, and also because of all these projects that it's doing.
Il terzo elemento di piacere nell'essere qui presente oggi è dato dal fatto che questa facoltà ha sempre avuto una vocazione che le consentisse di ambire ad andare oltre i confini, oltre certi tipi di ambiti, anche territoriali, anche geografici, anche culturali, e il progetto che oggi giunge al suo anniversario dei 10 anni ne è evidentemente una espressione paradigmatica. Qui molti anni fa si pensava già al senso della circolarità delle persone all'interno del pianeta, si pensava già a dei giuristi consapevoli e strutturati che potessero muoversi, che potessero ambire ad uscire dai confini. E questo anniversario, questo evento colloca ancora una volta questa piccola città di provincia al centro del dibattito giuridico-culturale, non solo italiano ma evidentemente anche internazionale.
This faculty had always had a particular vocation for this kind of project and for all the projects that go beyond geographical and cultural borders. And the Transnational Law Program is a clear expression of this. And Trento, for many decades, for many years, has been thinking about the juries as someone who can travel across the borders. And again, the Transnational Law Program is putting Trento in the middle of this debate.
Ultima considerazione, che però mi piace molto fare, perché in realtà tiene molto alla mia professione, cioè la professione di avvocato. Io credo che qui fra di voi ci saranno molti studenti che arriveranno a fare la mia professione. Fare l'avvocato significa parlare di diritti, parlare di tutela dei diritti, significa parlare di libertà. E sotto questo profilo parlare di libertà significa andare oltre, ancora una volta attraversare i confini, i pregiudizi, andare oltre i poteri per cercare di tutelare i diritti di tutti. E anche questa è una bellissima modalità per collocare questa giornata di oggi, attraversare i confini e sperare e augurare a ciascuno di voi di diventare degli avvocati europei, internazionali, ma davvero con quello spirito che l'avvocato ha e sente di avere, cioè dei difensori dei diritti delle persone, anche dei più deboli. Grazie.
So, as a last thing, as this project is about the career of a lawyer, and and I am a lawyer, I think we need to talk about the fact that being a lawyer means being someone who, as a job, talks about the law, talks about human rights and freedom. And freedom, in a certain way, means also the freedom to cross the border, to be able to fight all the causes and for human rights all around the world, in order to defend the rights all over.
Thank you, Sarah. All right. And now, Sarah, first of all, I think she did a wonderful job in translating. And now the floor is yours, Sarah.
Thank you. So, dear President, dear professors, and of course, dear students, it is a real honor for me to be invited to this event and to represent the students group of the Transnational Law Program. When I was admitted to the TLP and when I went to the Washington University in St. Louis in 2012, I felt very privileged. And I was aware that I was getting into a very challenging experience. But I had no idea that this experience would have not only impacted my studies, but it would have also given me a new and more global approach to the law. I thought that this project would have offered me the possibility to learn about a different legal system. But it was only when I arrived there that I understood that it also gave me the chance to learn in a different legal system. From this perspective, I started to observe and see my own legal system from a different angle, learning aspects of the Italian legal order that were not really visible from the inside. Soon I realized that this type of transnational education had much in common with the methods of comparative law. And this because comparative law uses tools and methods that allow jurists to analyze all the different legal models, some of which are original, some other not, which are part of a wider legal order. In the same way, thanks to this type of transnational education, I realized how much the Italian models are shaped and influenced by the Italian legal education. This dialectic approach gives the idea of how the aim of the Transnational Law Program is not just to give the student a technical knowledge of a different legal system, but also to introduce the student to the legal education and the legal reasoning on which that system developed. Giving life in this way to the image of a transnational jurist that is able to approach a legal problem from different ways, and who, in the future, may lead towards the figure of a rounder and more complete global jurist. The Transnational Law Program, far from being a point of arrival, seems a first step towards that direction. I would like to conclude by underlining that now I understand that the double degree, the LLM in the USA and the law degree in Italy, is not the only result we gained. I strongly believe that the experience itself offers something that is even more valuable. And even if that something doesn't stand in black and white on a CV, it gives us a glimpse of this image of the global jurist, which is starting to take shape. We all feel very lucky and honored to be part of the Transnational Law Program. And I really want to thank, in the name of all the TLP students, all the people who work so hard to make it possible. And I also want to wish all the best to the students that are now in St. Louis and to those who will join the program next year and in the future. Thank you.
Well, thank you all for your introductory words. Professor Angioli, on behalf of the Dean, and you on behalf of the Bar, and you on behalf of the students. I think it's clear what the value of this program is, and I think it's really good that we celebrate that. What a better way to celebrate than ask Professor Cassese to talk about the global dimensions of democracy in a period where I think democracy is under pressure. So it is with eagerness that we await what you are going to tell us.
Yeah, but let me first move this. Oh, I can see you. You know that I'm going to speak about the global dimensions of democracy and the rule of law. You may know that Article 2 of the Treaty on the European Union provides that, I quote, "The Union is founded on the values of the respect of human dignity, freedom, democracy, equality, the rule of law, and respect of human rights." And you may also know that according to Article 7 of the treaty, if a member state breaches these values, the Union can resort to a preventive procedure and to a sanction mechanism. Now, on the basis of these two provisions, Article 2 and Article 7 of the treaty, the European Parliament passed two resolutions in 2015, voicing concerns on the situation of democracy in Hungary, and they were not successful. But on the 12th of September of this year, 2018, the European Parliament passed this resolution on a proposal calling on the Council to determine the existence of clear risk of a serious breach by Hungary of the values on which the Union is founded. And this has referred to the breach of the principles of democracy and the rule of law. And during the discussion on this resolution, Viktor Orbán, who is the leading figure in Hungarian politics, said, "Hungary's decisions are made by the voters in parliamentary elections." So use the argument that democracy in Hungary relies on the decision of Hungarian people, opposing the will of the people, of Hungarian people, against the provisions and the resolutions of the European Parliament. Now, if compliance with the rule of law, respect of human rights and observance of democratic principles are tasks not only for national legal orders, but also for supranational and global institutions, many questions arise. Is there a universal concept of democracy? Is democracy a universal and shared value? Is there a universal right to democratic governance? a right that is necessarily a global right? Is there or can there be democracy at a global level? Is global democracy similar to national democracy? Does globalization hollow out national democracy? Or on the contrary, can global bodies enhance national democracies? If the state is the cradle of democracy, what will happen to democracy if the state becomes less important and decisions are increasingly taken by supranational or global actors? Will national democracy evaporate, or will it be replaced with a cosmopolitan form of democracy? I shall address only two of those questions. So my lecture will be divided in two parts. And the first, I shall consider the possibility of transplanting democracy at the global level. And then, in the second part of this lecture, I shall analyze how globalization affects national democracy and how global and national democracies interact. Let me start with the first question. Is there or can there be a global democracy? Now, you may know that the principle of democracy is codified in a range of supranational instruments and has therefore become a principle of international law. According to these supranational instruments, treaties, for instance, conventions, democracy must be promoted, supported, and defended as a human right. Democracy is considered a condition for becoming a member of some international organizations. In other words, if a state is not democratic, cannot become a member of an international organization. Democracy is established, therefore, on two levels. One is peculiar to each national legal system, each national government, each state. And one is universal and shared. And a well-known professor of international law, Thomas Frank, who was a professor at the NYU Law School, wrote in an article published in 1992, so many years ago, he wrote, I quote, "The international system is moving toward a clearly designated democratic entitlement with national standards validated by international standards and systematic monitoring of compliance." And the title of this article was "The Emerging Right to Democratic Governance." On the other side, another well-known American scholar, this one not a lawyer but a political scientist, Robert Cohen, has written in an article published in 2015, I quote, "The symbols of democracy are all around us as we contemplate the institutions of global governance, but the substance is elusive. Global democracy, according to Cohen, is merely nominal. While the global space is no longer a bureaucratic bargaining system, global institutions, according to Robert Cohen, appear to enjoy only indirect legitimacy through their member states, as there is no cosmopolitan parliament, and that's true because there is no cosmopolitan parliament, no global public sphere, no global public opinion, and no universal elections. So you see two opposing points of view by two leading scholars, a lawyer and a political scientist, both American, one supporting the point that there is a right to a global democracy, not only global democracy, but the right of people to have a global democracy. On the other side, another one who says, no, yes, it is written on paper, but this is a law in books, is not a law in action. In reality, the substance is very elusive. Now, I want to pause a little bit on this conclusion and consider two elements that could lead the quest for global democracy down different paths. The first, I think that we should ask ourselves whether the global environment is similar to that of national governments. And if it is different, where the peculiarities of the global context lie. So my first question is, are we sure that the global context is similar to the national context? And the second question is, we should consider whether, given the different context, suppose that there is a different context, democracy could establish itself in the global space through different means, through different instruments. So, supposing that the global environment is different from the national environment, at that point, it is possible that democracy can be established at the global level through different instruments and procedures. Now, let me consider this first point. The history of global institutions is very different from that of national institutions. We know that states, national governments, grew out of divided societies, developed around a united and strong executive, Louis XIV, and gained the power to use the force, the power to tax, the power to wage wars and maintain armed and police forces. Later, states, national governments, became welfare states and therefore developed what we call now the spending power of the state. That is the power to allocate and reallocate resources. During their relatively short lifespan, on the other side, global and supranational institutions, WTO, the United Nations, the European Union, Mercosur, NAFTA, developed along very different lines. There was no central authority. They are not united. They are fragmented. Each institution at the global level has a single task. For instance, to regulate the law of the sea. Thank you very much. To control the use of nuclear waste, to oversee international trade, to deal with global health. For each one of those tasks, there is just one global institution. Therefore, in the global environment, power is not united. Power is divided. There is no centralized body. And there are very limited power of enforcement, as the enforcement of most global and supranational decisions requires state cooperation. There is no centralized police or army beyond the state at the global level, no taxing power, and almost no spending power. Consider the European Union. The European Union is, from a regulatory point of view, is a giant. But if you consider the spending power of the European Union, you can compare the spending power of the European Union to the municipality of Milan or to a local institution. If global institutions act as initiators or promoters, they do not impose burdens. If they can impose burdens, they cannot give orders. If they can issue guidelines, they must nevertheless rely on national authorities for implementation. They do not act directly to interfere with free speech or religious beliefs. In limited cases, they may constrain, but they cannot impose obligation. Only in very limited cases, they may infringe upon individual rights. Now, if the main task of democracy is to place and maintain power under control, this is the main purpose of democracy, the kratos of the demos, krateia of the demos, the power of the people. If national parliaments and subsequently universal suffrage developed for the main purpose of imposing limitation upon the executive power, democracy at the supranational and global level does not have any such duty to accomplish, for the simple reason that the nature of the global system is different. The concepts of democracy, as embedded in the state experience, cannot be transposed as such into the global polity. It remains one open question, which is where from global institutions derive their legitimacy if there is no cosmopolitan parliament. The first source of the legitimacy for global institutions, that is the first way to democratize global policies, is of course state consent. This point was made by Robert Cohen in the passage that I have quoted before. National political leaders play a double role, as they are both members of the national ruling classes and also global policy makers. They are therefore twice accountable to the national electorate. This is a special type of indirect democracy, as global democracy through state consent and support does not only mean that every single member state supports the global institutions of which they are part, but also that this support is provided by the collective action of national governments. By this I mean that it is not true only that the Professor Conte, who is now the Italian Prime Minister, when goes to Brussels, is supporting, in a way, giving legitimacy, indirect legitimacy, to supranational institutions, but also that he is giving this legitimacy together with Frau Merkel and with President Macron and the other members. So they collectively provide legitimacy to supranational institutions. A second source of legitimacy for global institutions consists of global parliamentary assemblies. Parliamentary assemblies, composed of representatives of national parliaments, are not unknown to supranational and global organizations. For instance, the Parliamentary Assembly of the Council of Europe, the Mercosur Parliament, the Pan-African Parliament of the African Union, ASEAN's Interparliamentary Assembly, NATO's Parliamentary Assembly, and Parliamentary Assembly of the Organization for Security and Cooperation of Europe. And of course, on top of this, there is the European Parliament, which was directly elected by the people in Europe. I now return to the question that I have raised before. Does global democracy mirror national democracy? Or should one conclude that democracy acquires different characteristics, different features in the global space? An analysis of the structure and the decision-making processes at the global level reveals that there are two prevailing forms of legitimacy and accountability building mechanisms. One that is horizontal, and the other one which is vertical. First, as interdependence is a predominant feature of the global space, external restraints play an important role. As members of multilateral global bodies, national governments can control each other. This is different from state consent as a source of indirect democratic legitimacy, because the latter acts in a vertical, bottom-up direction, while this is mutual control mechanism acting horizontally. This concept of horizontal accountability was developed by a South American scholar who then became a professor in North America, in the USA, a university professor with the concept of horizontal accountability. We are each one responsible to the others. You can read the newspapers of these days. Mr. Draghi, what did he say yesterday? He said, well, Italians, fellow Italians, take into account your problems, your financial problems, because you are accountable to the other countries of Europe. Because if you don't behave well, according to the principle of virtue, which was developed by Condorcet, famous member of the Enlightenment movement in the 17th century, at that point, somebody in Germany or in France or in other countries, in Spain, will pay the price. Not only you, but also other people. So this horizontal accountability is very important, and we will see as Italians, as a member of this community, we are now seeing a procedure of horizontal accountability. The second, transparency, participation, review, contestation procedures, and the duty to provide reasons for decisions contribute to alleviate the perceived democratic deficits. Principles such as the right to a hearing, the duty to provide a reasoned decision, the duty to disclose all relevant information, developed and were enforced in the global space in just a few years, some 15, 20 years. While the same principle developed in the national settings during centuries. Consider that the first law which provides a regulation for administrative procedure was enacted in the USA and was the American Administrative Procedure Act 1946, that a similar law was enacted in Germany in 1978, that the similar law was enacted in Italy in 1990, and Italy was united in 1861. It took more than a century to develop such a principle, such a set of principles inside the national governments. The same set of principles were developed in the global setting in just 15 or 20 years. And this gives you an explanation. And this is deliberative democracy. This is participation of the people to the decision-making process. And the deliberative democracy can replace representative democracy, can play the same role of representative democracy in the global space. So my conclusion on my first point, I don't know if I was able to convince you of these arguments. My conclusion is that it cannot be said that global institutions are not democratic, because citizens can never attain influence and control over global decisions, because there is no cosmopolitan parliament, no cosmopolitan elections, because the views of the elites tend to prevail, or because there are no opportunities for political participation, information of political decisions, public debate, political competition, or control over international bureaucracies. On the contrary, it is possible to conceive of and practically achieve the democratization of governance beyond the state, on the supranational and global level, as well democratic politics beyond the borders of the nation states and without one unified people. So, in a short summary, my first conclusion is that a different context requires a different concept of democracy. And this different concept of democracy is basically based at the global level on two means, which are, one, horizontal accountability, and two is deliberative democracy in the place of representative democracy. I now move to my second point, which I suppose will be shorter. My second point is, do global institutions reduce or enhance national democracy? So I moved from democracy at the global level, I'm moving to another point, which is, can the global level have an impact on national democracies? And is there a possibility of an interdependence between the two levels, the global and the national? Is globalization a friend or a foe of national democracies? Does it have a positive or a negative impact on national democratic systems? Does it promote, defend, and enhance national democracy? Or, on the contrary, does it constrain democracy at the national level? In other words, are democracy and globalization two opposed ideals? If the state is the context in which democracy developed, and we know that democracy developed in the national governments, in the states, what will happen if the state becomes less important because of globalization, because global institutions take decisions which were previously taken by national governments? Does this conferral of sovereign power from national governments reduce democracy and undermine the legitimacy of national governments, given that the national electorate cannot regain control over decisions? You can understand that this is the point made every day by Mr. Salvini, one of the Italian vice presidents. You know? This is the argument. Yeah? Decisions which were taken in previous times by national governments are now taken by supranational governments. This, as you know, is a real concern, not only because of Mr. Salvini, but also because of the German Federal Constitutional Court, in a famous case on the European Stability Mechanism. According to a judgment by the Bundesverfassungsgericht, if further European Union integration is to be online with the basic law is the German constitution, any additional transfer of power must be democratically legitimated by the Bundestag. So every decision must be taken first by the German Bundestag and then by the European Parliament or the European Council. There is a point made by a famous, well-known, highly respected German professor of constitutional law, Dieter Grimm, who was a professor at the Humboldt Universität, is now retired, who wrote shortly, maybe a few years ago, I quote, "As long as there is no convincing model of global democracy, the source of democratic legitimacy and supervision must not run dry at the state level, because today sovereignty protects democracy." You can hear Salvini, the everyday Salvini. Now, globalization has an impact on national democracies because many decisions are no longer under the control of national governments because the power to make them has been transferred to global or supranational authorities. I'm always referring to global and supranational. By supranational, I mean the European Union or Mercosur, and by global, I mean WTO, OMS, or the UN, or other institutions which are really global and require participation from all over the world. National executives are no longer act as guarantors for these decisions. They are only able to cooperate with their counterparts. The Italian Prime Minister going to Brussels when taking them, and national governments are themselves subject to their binding power. So they can cooperate in Brussels with other prime ministers, but then they are bound to the decisions which were taken collectively at the supranational level. At the same time, national governments are accountable to their respective peoples, which do not distinguish between the two levels of government. That is, Professor Conte acting as a Prime Minister of Italy or Professor Conte acting as a member of the European Council. And direct, I mean, the national people, the people in national governments, and they direct their criticism towards national executives, which are their own representatives. As a consequence, national governments are held responsible for decisions that were taken in cooperation with other authorities and over which they did not have full control. It is clear that the Italian people has no such control over decisions which were taken collectively in Brussels because were influenced by other representatives of other people, the Germans, the French, the Spanish, the UK until now, etc. This asymmetry activates a process in which national political parties accentuate populism and demagogy, and we know in Italy this, while criticizing globalization, and national leaders must play the role of mediators between popular demand and global institutions. This is one side of the coin. Now let me move to another side of the coin. However, on the contrary, globalization may also serve to democratize domestic governments. Global actors can foster national democracy by establishing standards and evaluating best practices. For instance, the Organization for Security and Cooperation in Europe, which sets standards for national elections. Second, by funding, rewarding, and promoting national grassroots initiatives, as the UN Democracy Fund, and I will say a few words in a moment on this special institution. Third, by adjudicating cases involving national democratic institutions, as, for instance, did the Strasbourg Court, the European Court of Human Rights, in the decisions on the voting rights of the British prisoners, by helping in drafting domestic legal frameworks, like the famous Venice Commission, by putting national elections under observation by global institutions, by assisting and supporting national democratic processes, and finally by establishing that democracy is a condition to access global or supranational institutions. And the famous case is the Turkey case, the conditionality established by the European Union for accession of Turkey to the European Union. Just one example, the UN Democracy Fund. The UN Democracy Fund was established in 2005, has an executive head, a secretary general, an advisory board, and program consultative group. 45 member states contribute to the fund, which provides funding to civil society organizations. And we have a similar institution in Europe. The European Union has established another institution, which is called the European Instrument or Initiative for Democracy and Human Rights. What do? Well, they finance grassroots organizations. Let me give you one example. The UN Democracy Fund is funding many associations of women in national governments to support the action of women in countries where there is universal suffrage only for men and not for women. Now, introducing women participation means enlarging suffrage and giving more democracy to a country. In this way, this fund is bypassing national governments. Suppose that the fund is here, they are bypassing national governments, they are giving money to civil society organizations, and civil society organizations are putting a pressure on national governments in order to make the national governments more respectful of the principle of democracy. So you see how the global level can introduce an incentive, a promotion of democracy at the national level. I want to finish by underlining 6 main features and maybe some paradoxes of this global enhancement of national democracy. You understand that my point the conclusion of my second point is that, contrary to the point made by the populists and by many national governments and many political leaders, contrary to their point of view, national governments can become more democratic through the action and the intervention of global institutions. So the point of view of the present Italian government has to be reversed, so to say, because national governments can, the national democracy can be increased through the pressure of global institutions. Now, as a conclusion, I think that one can say that there are 6 features and paradoxes. 1, global or supranational institutions often address their action to civil societies directly to empower them, bypassing national governments. Therefore, national governments are under a double pressure from above and from below. And this is the case of the UN Democracy Fund or the European Instrument for Democracy and Human Rights. Second, although democracy is traditionally generated by the people in a national context, it may also be encouraged, imported, transplanted, promoted, assisted, and controlled from the outside. So democracy is not necessarily only the outcome of domestic political processes without any influence by actors outside the nation state. Third conclusion, in this context, we are witnessing the paradox of a set of new global and supranational institutions that are not themselves entirely democratic, but that promote, assist, support, and judge long-standing and well-established national democracies. This is the paradox of the famous set of cases before the Strasbourg court. I mean, the oldest democracy in the world, the British democracy, they were the first experience, and in a way, every country in the world looked at the British democracy as the example of democracy. And in spite of this, the Strasbourg court, where sit countries who are not entirely democratic, took a decision that the British democracy is highly imperfect for a very simple reason, because they don't give the power to participate to national elections to people who are put in prison, which is basically a principle shared by most of the so-called latecomers to democracy. Italy was a latecomer to democracy. Germany was a latecomer to democracy. France was a latecomer to democracy as compared to the British. So you have, in a way, a reversal of the historical lesson. Fourth, by upgrading national democracies, global and supranational bodies assist domestic publics to achieve goals that they would otherwise have difficulty realizing. Fifth, democracy-enhancing global policies are not justified only in terms of democracy. There is an additional reason, that is their capacity to maintain peace, given that democracies are supposed to be more peaceful. And sixth, there is no doubt that the role of international and the transnational actors in contemporary democratization processes is increasingly important. So in conclusion, global interventions as foreign interventions do not necessarily entail a loss of democracy. On the contrary, they can protect or even promote democracy and can compensate for the powers that have been removed from national democracies. Now, to establish a link between this lecture, because I am at the end, I want to say just a word about learning in the global legal environment, which is the title, the general title of this session. Just to underline a paradox that we are living now as scholars, researchers, and you are living as students. And the paradox is the following, that there are many global institutions, 2,000 global regulatory regimes, 2,000 global regulatory regimes, 60,000 NGOs at a global level. There are important rules we use every day. We are now 7,300,000,000 inhabitants of this planet. Half of us, we use internet. Internet is under the regulation of ICANN, Internet Corporation for Assigned Names and Numbers. So the global regulation, the global institutions have an important role in our life, in our daily life. When we use this machine, we are under the regulation of ICANN. You see, ICANN is the global regulator, the final regulator of this small machine. Moreover, there is an important amount of research. Researchers all over the world are working since 30 years on global law, on globalization, on global administrative law, and global law is affecting every side of national law. And of course, you may know that international law has a much longer life. There is what a French scholar called in a seminal and famous book published in 1985, Jean-Claude Cointanugy is the author, Le droit sans l'État, le droit sans l'État, the law without the state. No? So there is a law which is beyond the state, without the state. But in spite of this, we continue to teach law as if the law was only the Italian law. There was only the Italian Constitution. There was only the Italian Civil Code. Because we assume that there is a big difference between a chemist, a physicist, a medical doctor. Because medicine does not change from Italy and China. If you are a medical doctor, you can go to China and become a medical doctor. Be a very good doctor. But if you are a lawyer, you are an Italian lawyer. You are a French lawyer. You are a German lawyer. You cannot go to China. There is no dialogue between you and China. Why? So, I want to call your attention on this paradox. We must learn to be universal. Thank you very much.
Professor Cassese, thank you very much. This was a very, very inspiring lecture. basically what you are talking about are the consequences of the disintegration that we now seem to see at an institutional level and supranational and the global level. And you looked at the argument for that disintegration by those who say, well, but these institutions are not democratic. And democracy can only be within state boundaries. And what you're arguing is that is not correct, because there can be a different type of democracy, deliberative democracy. But we should not forget that what happens in Italy or United Kingdom or anywhere else has an effect on other countries as well. I think you focused on Italy. You could as well have focused on the United Kingdom and Brexit.
Yeah, of course.
Because that is where we see the process happening.
I know.
But thank you for your analysis. I think that is very helpful. And I think it is encouraging for all the students sitting here to hear that they made the right choice for this particular program. So thank you again. All right. We now move to the second part of this symposium. And I'm going to say goodbye to Mr. Bertolini. And while Sarah is staying, we have three speakers. And let me see, I think they come forward, right?
And I think that I'm leaving. No, but I must leave. I will join you again later on, but they asked me to speak to another. You go.
I have to get back. Thank you very much. I really So I'll probably stand up. Is that right if I stand up?
That's okay. No problem.
That sounds good. Good to see you. Yes. Very nice to see you.
Right. Right now, the speakers changed places. We can continue with the second part. I will introduce the speakers one by one. I think that's the best. And our first speaker will be Michael Coby, who is an Associate Dean at Washington University, St. Louis, Missouri. To be honest, I looked a little bit over his shoulder when he flipped through his presentation, and I think we're going to have a wonderful presentation. So the floor is yours.
I guess. You know, with that setup, better be good.
Okay, the floor is yours.
Yeah, very good. I'm going to stand up because if I could see my own presentation there.
I think I better move, so
There we go.
if you don't mind,
Okay.
Yeah, no
so I
worries.
can watch.
Okay.
So glad to be here. I know that I see some great
Okay, right.
former colleagues for part of the TLP program, and I can tell you that we have been thrilled with our students from Trento. I can't tell you how many times I've heard how great our Trento students are, and just our community, our law school, has been a better place because of our Trento students. And I hope they feel that, that you're a part of our family and that we really love you as a part of our community. So I feel a little bit odd giving a presentation on being a transnational lawyer, because I don't think we're very good at it in the United States. It's like coming here to give a presentation on climate change and how to deal with global warming. I think it's a little odd, or me giving tips on bodybuilding or weightlifting. There's certain things I shouldn't talk about, but we're getting better. And I can tell you that there's certain things that I have regrets. I mean, I love my life, right? I have a great wife. I have 2 great kids. I have a job that I couldn't be happier in. But one of the things I've realized over time is that that I wish I would have invested when I was a student. I wish I would have invested earlier in my career in really understanding the landscape of what the law looks like internationally. And I've realized over time that U.S. legal education, I think, is behind We don't require, for example, a comparative law course. I would guess if you were to talk to even most U.S. faculty members, their ability to describe common law systems versus civil law systems and the basic parameters, I think some would be at a loss to do that because, like in many areas, we tend to be a bit provincial, a bit inward focused. Our courts don't look at international law. In fact, I remember several years ago now reading Justice Scalia's scathing report about how the Supreme Court, different justices and lawyers were talking about the death penalty in Europe and other places. And so it's not a strength to really consider and think globally. And so I'm excited about this program because it's doing just that and changing the legal culture in the U.S. and legal education. I think it's slow in coming. I think more and more there is a sense of being able to be conversant and understand different legal systems. And so in my short period of time here, I just wanted to talk about a couple examples of why and how important it is to understand where legal systems are different and being able to educate yourself about different legal systems in the context of being a lawyer who can practice across borders. And oftentimes it's easy to think legal systems are pretty much the same. I mean, kind of on the surface they seem the same, and that's very true. There are a lot of similarities. You know, we have 3 branches of government, we have 3 levels of courts, but there are certain things that are just distinct, and being able to identify those and being able to get on this road of a lifetime of educating yourself about how the world operates in the legal world, I think you'll be far ahead of where I was, and I'm kind of slowly learning. And so I'm going to give you an example, a personal example, where my career was kind of directly impacted. And then I want to talk about kind of 2 examples of where you might think on the surface things are similar, but have a profound impact on your future clients maybe, and just the globalization of the legal world, but business and such. And so, there's my little, that's a title. Well, first of all, I want to talk about my example, and then I'll talk about 2 specific examples that are more general. The first is that I remember several years ago, I was doing some research, obviously being more on the academic side. I was comparing the treatment of new religious movements, and I compared the United States, Russia, and Spain. I had experience in Spain. I taught there for a year, which is even more embarrassing when I tell you the story. And I remember, doing the research. I was reading these horrendous Spanish Supreme Court, Constitutional Court opinions. Just they went on, and it was really taxing. And then I was finishing my research, and then I realized that I had no real understanding of the difference of constitutional adjudication in those countries versus the United States. And, in the United States, any judge, in fact, one U.S. District Court judge struck down Trump's travel ban. If you recall, he had a travel ban where he listed 6, 7 countries that said, these folks are restricted in entering. And I just always assumed that was how it worked. One judge basically put a hold on that in the entire country, and it went through the appeals process, finally reaching the Supreme Court. And I realized that that's not how it works in Spain. They have a constitutional court. It's submitted. The average judge cannot hold actions of other branches unconstitutional. It was completely the opposite, very distinct to what is done in Russia and Spain, and I know also in Italy. Although in Italy there's some similarity because it has to be actually involved in a case. There actually be facts. Whereas in Spain they actually write an abstract question of constitutional law and they submit it to the court. Maybe 10 years later they get a response. I think it slows things down. But I remember thinking, you don't know what you don't know. And your ability to get a broader education about how the world works, just not as we heard just previously, not just being an Italian lawyer, not just being a U.S. lawyer, but being able to practice across borders is something I regret not investing earlier in my career. And so 2 examples I'll give you about the U.S. legal system, which is what I do know. The first is federalism. Obviously, this is a picture of our country, map there. It's kind of showing the federal courts, and I could spend 3 weeks every day for a couple hours talking about this subject. This could be a course in the idea of federalism. But one of the basic principles that I think is distinct is the fact that we have two systems. We have a state system and we have a federal system. And I know what you're thinking, well, so do we. The difference is that the state system is where all of the law pretty much is made. The vast majority of law in the U.S. is in the state system. We have no comprehensive national code that covers most subjects. And so I use this door as a door, kind of an illustration of a door to state court. It's the court where pretty much everyone goes, except for a very limited number of subjects. The federal system, on the other hand, is a very small door. It's a system of limited jurisdiction. And so where does this come up? It comes up in the sense that the vast majority of law that affects the average citizen, contract law, most criminal law, torts, property law, family law, is all state. What does that mean? We have 50 state codes that define a lot of these things. We have 50 state administrative regulatory regimes. And we have 50 state court systems, as well as the federal court system. But the vast majority of law is really state law. The federal system is limited to a very limited number of subjects. Now, there's still a lot of federal law, generally things that affect interstate commerce, anything that has kind of a multiple states, or things like bankruptcy, patent law. There's a list of subjects in the Constitution. But that is distinct in the sense that if you're doing business and you have contract relationships, in fact, just yesterday I had lunch with a student in Milan, not from this program, his name is Aurelio, and he was talking about how his practice has been great since he's has this kind of this transnational practice. He has a case right now involving a window manufacturer in Italy who sold windows that were the wrong size to a New York corporation, and the fact that he is representing them in court in Italy, which he's arguing is not the right forum and all that. And I always thought that was arbitration, but he said that arbitration was so expensive that a lot of it goes through litigation. But every state has unique law that if you're going to have any type of interaction in the United States, being able to understand that principle is absolutely important. So I'll give you one example that deals with these keychains. My father-in-law actually owned a company in which he manufactured keychains, imported for them from China. He calls me one day and he says, "Mike, you're not going to believe it. I'm being sued in California." And I said, "Well, I do believe that because they sue a lot of people in California." And he said, I am getting sued because my products, my keychains, these keychains, did not label them correctly in California. They contained some chemical, even name it, that causes cancer. If you've ever been to California, everything's labeled to cause cancer. You just get it everywhere, whereas I guess in Missouri you don't, where I'm from. But these keychains, I said, well, yeah, that's a law in California. And he said, well, do you mean that every state where I sell my products, I have to look at their laws and follow their individual labeling requirements, as well as in the federal system? And I went, yeah. Because that's unique. That's what our federalism is. It's the law is state by state. Contracts, state by state. Huge difference. And again, really has an impact on practicing cross borders. The second example is this idea of what is law in the United States? And this is one we could argue because there's some similarities and not. And this is kind of a broad question. But what is law? In fact, one of my colleagues was asked this, and I was listening to him talk to a group of Korean lawyers, and someone asked that. You know what his answer was? Law is what the judge says it is. And that's a second unique aspect of, now that's technically not true because you know what, we have statutes, we have regulations, we have constitution, just like you would have here in Italy. Now we do have common law, and usually people understand that. Common law is judge-made law. There are common law subjects like contracts, property, torts. A lot of law is defined by judges. But it's really pervasive. And the fact is that, we have 4 sources of law, right? And you're thinking, well, this is very similar to Italy. We have a constitution, we have statute, we have a code, very similar. We have administrative law, rules or regulations. You don't have common law, at least to the extent that, unless I'm missing some change in Italian law. But you don't have common law, and you get that. That's kind of coming from the British system. But when you look here, it says that constitutions are enacted by legislatures, but interpreted by courts. Codes interpreted by courts. Administrative law interpreted by courts, and then, of course, common law is case law, right? The point of this is that the judge and rules from the courts really is about 90% of U.S. law. Now, I mean, I've read that several times. It seems really high for me because we have a lot of statutes. We have a lot of regulations. But it's really the judges and the opinions of the courts that define a good amount of U.S. law, which is distinct from Italy, I would imagine. Now, I know you have some case law and such, but the extent of it, and our students, I think, who have studied in the U.S. Will tell you that even if you take a course that is all statutory based, you read the cases, do you not? You have a case book about tax law. Well, tax law is statutes, but it's all about the cases because the courts are the primary lawmaker in the U.S., even when it comes to the statutes, the Constitution, and regulations. They have a huge role in lawmaking. This comes up in a lot of contexts, but I had one student who was from Japan, and he was telling me a story, and a lot of our Japanese lawyers are corporate counsel. And he was telling me about how he didn't understand it, but that contracts in the U.S. are much longer than they are in Japan. And as we were talking about it, he was saying how in Japan there is a comprehensive code that sets out all of the terms. So the contracts are very short. In the U.S., everything's up for grabs. It's kind of much more, there's not a comprehensive code. It's a common law subject with some exceptions. And so the terms of it are part of the contract. And so oftentimes Japanese companies will draft their contracts without lawyers. And they will then, at the end, have the lawyers bless the contract. Whereas in the U.S., lawyers are involved from the very beginning, and there's oftentimes a mismatch because the Japanese companies are thinking, well, it's covered by the code. We don't have to worry about delivery terms. It's in the code. Very different. And so, those are just, two examples of the importance of being a kind of taking time at this point in your career, as our students in our TLP program have done already, and hopefully I'll be able to greet many of you in St. Louis in coming years, taking the time now to get on that road to being a truly transnational lawyer, understanding the basic confines of other legal systems. And I think there's a lot to celebrate. I love being here. The fact that it's been a great program for us, and thank you to Trento and Professor Giurisprudenza for her work and your just great organization of a very complex program. We're very proud of it, and there's just a lot to celebrate. And I'm glad to be here to be a part of it. Thanks.
Well, I've heard once an English judge say that even statutes are statutes do not apply until we as judges have applied them. Right, think about that. So, okay. Our next speaker is a good friend of mine in the Trento Law Faculty. I think I can say that. Roberto Tognatti. He is a professor of constitutional law and a former dean. Comparative Constitutional Law.
If you don't mind, yes.
Well, I'm just reading what it says.
Well, that's a mistake.
Okay, right. You see, it doesn't apply until the speaker said it, right?
Right.
Right. Okay, there we go. So the floor is yours.
Thank you. So thank you very much for giving me the floor, and I would like to say a few words just for the celebration of this particular event. And I will not follow what Michael Coby has so brilliantly told us, just because I'm quite older than he is. And I took part in the early part of the negotiations in order to get to the Transnational Law Program. And I remember that the very first idea was not the way the TLP is now. And I'm sorry that Professor Cassese is not here, because it has very much to do with the very final words of his introduction. The very first idea was from Tom Swart. Yeah? And that was in the late 90s. And we were both members of a group. Professor Cassese is also a member of that group, the European Public Law Organization, which meets in Greece every year. And Tom said, I analyzed the programs of many courses in different law schools in Europe, and I'm sure that about 70% of what we teach is the same. And we took the example of constitutional law, and he said, and he was correct, we all teach about Parliament, we all teach about the French Revolution, we all teach about mutual confidence, we teach about checks and balances, the head of state. Of course, the rules are different, the regulations are different, but the main ideas, the main institutions, at least on the continent, of course, are the same. And so he said, we should find a way to have one person teaching what is common to all the legal systems in Europe, and then to have somebody else who teaches the difference. So that what Professor Cassese said, after all, we are German lawyer, the Italian lawyer, French lawyer, Dutch lawyer, should be at the end, not at the beginning. So rather than starting with Italian law, as if Italian law were the law, and then adding some references to the Dutch, to the German, to the French law, we should just do the other way around. Now, this was not achieved also because, as you understand, you need a lot of teaching staff to do that. Although, of course, it was my idea that the national version of the course could be taught by persons who would go to Maastricht, for instance, just for 2 months or 3 months, because the core of the teaching has been given already. Then this ideal was not achieved also because the United States popped in, and that would be more difficult to do the same kind of teaching with the US, although, of course, it is true that there's also a head of state, there is a government, there is a judicial system or whatever. But the truth is that we should add more time to teach differences, considering also that, as you said, state law is a great part of law. But what part of the teaching of law in law schools is? I understand you teach mostly federal law, federal civil procedure, federal torts and the like. And the teaching of state law is very limited, isn't it?
It's a general, we teach general state law, and then when you learn your specific state. So the first year is all state law, but it's general principles, and then you take the bar in your individual state.
At the end of it, yes.
Yeah.
Yeah. So anyway, that was the very idea. And we think that, and I think that although Tom Swartz's original idea was very brilliant, I'm delighted that we changed in order to accommodate the needs that were introduced by the presence of the Washington University in St. Louis. Now, let me also recall the fact that here in Trento we established a committee that was in charge of this program, but as it always happens, the committee did not work as much, but it worked through Elena Ioriatti. So she was a committee by herself. And in such enterprises, you always need somebody who is more convinced than others, more willing than others to work and spend time. We also had a very nice experience, I have to say, in general, with Utrecht University also. We also had an exchange of administrative staff, as I was always convinced that also the administrative staff must be familiar with the environment in which a program of cooperation takes place. I remember a number of things, for instance, that we started also thanks to the funds of the European Union. We started within the framework of the Atlantic program. So every time people try to put you against the European Union, try to think that something good the European Union has been doing. And also, I have very many memories. I remember the very last meeting in Brussels on a Sunday, because we had to accommodate the requirement of the European Union program. and it was difficult to find a place where to have lunch, but then eventually we did accomplish also lunch, plus the Atlantic program. So it was very good. But let me also say that very little might have been achieved without this extremely cooperative attitude by Washington University in St. Louis. I would say very far-sighted cooperative attitude, and I would also add a very generous attitude on the side of Washington University in St. Louis, so that we are absolutely delighted to have such a partner within the program. And in fact, just a short time ago, I was in Japan at an international conference in Fukuoka, the International Academy of Comparative Law, and there was a young lady, and I spoke about the program, and she said, well, if you come to St. Louis, please remember we are also there. We are a small university, but almost as good. So I should remember that that young lady, that colleague who would like to be part of a network as Washington University in St. Louis is. So this is for the celebration part. But let me come to the title of my presentation, which followed, which was inspired, in fact, by Michael Coby's, and the title is The Case for Preparing the Transnational Law Professor and Readjusting Law Schools, which I think are two necessary steps that you have to take into consideration when you want to be present in the global legal forum. And let me recall previous experiences of a fundamental transition that we experienced in Europe in emphasizing legal education as part of the academic itinerary of most of us, so that at some stage we needed to ask ourselves how to prepare the European law professor and European law schools. Now imagine, Michael, now of course Missouri was not a member state in 1787 where the Constitution was drafted, but imagine that you wake up in the morning and you find out that your state is a member of a federation and that you have to take into consideration a much more complex of sources of law, a much more complex system of interaction between national and supranational jurisdictions. Now, I would say, if you don't mind, our generation, at least the two of us, experienced this kind of transition in Europe from purely national law to European integrated law. And this has been already an experience that made us think how to adjust to the new legal environment. And mind you, in the very early period, it was a practice that each course would teach some foundations of that particular area with regard to European law. So you would have, in the course of criminal law, some foundations of European law, private law, corporation law, and whatever, constitutional law. But then at some stage, in particular, I would say after the Single European Act in 1986, we realized that you couldn't just divide the teaching of European law from the rest, because you could not teach national law without making reference to the integration phenomenon, to the integration process. So that, in fact, we should have abolished a course of European Union law and have European Union law introduced into each one of the courses. Now, here in Trento, we took a different path. We did introduce, and we have been the only law school in Italy, having a mandatory course of introduction to EU law on the first year, precisely because EU law affects the system of sources of law in the way that you know. So I don't want to go more into detail about it. And other courses are so busy that they could not give enough space and attention to the contribution of European law to the different areas. And so this was, let's say, a first adjustment to a first transition of legal education and of legal systems. I remember I went to a conference in 2002. The conference was on working across Europe, the implications for university law schools and legal professional bodies, and I published an article that is entitled "The European Lawyer, Phantom or Reality." It's quite naive, wasn't it? But that was the year 2002. And let me just quote a very short passage. In other words, teaching and learning and later practicing European law, at least the fundamentals, the central core of it, must be the target of all law schools and of all prospective lawyers, whether they be professionals in a law firm or self-employed or employed in the public, private, or the third sectors. One can also notice that, apart from radical changes in the treaties, substantive European law is already and will be in the near future a permanent area to be properly included in programs of lifelong learning or continuing professional development. If the European lawyer is more a phantom than a reality in 2002, then at the same time, this was my provocative statement, the national lawyer himself or herself has become a phantom and is not a reality any longer. So in other words, you cannot avoid being a European lawyer or, as I indicated here in this article, an integrated lawyer. So I would say that with the same attitude, we face now this second transition in my lifetime, and in fact I'm almost going to retire, and that's good because I will be able to adjust myself again to a new dimension, although I'm trying to do my little best. Considering also how global law is different from European law. In fact, global law is quite different, at least in this stage. Now, I think that the presentation of this symposium has been accompanied by a very accurate and, I would say, smart text. Please do read it. It's those lines under the headline there. It's, I think, very, very smart, although it says at some stage to handle such a new legal environment, the global new legal environment. And then in a later part it says the global order. Now, is the new legal environment an order or is it a disorder? And I would say this is not only a rhetorical question, but we heard also Professor Cassese speaking of the plurality of institutions that are meant to somehow enhance democracy, and he said absolutely correctly, there is no single institution in charge of everything. In other words, we do not have a world government, and as a matter of fact, I'm delighted that we don't. So globalization is more and more is a process, an ongoing process. And so how to teach and what to teach, more or less the same questions that we asked ourselves earlier in the early period of the establishment of the legal system, of the legal order of the European Union. Is there a global legal order or a global legal disorder? Is there a systemic approach that can provide an explanation to a number of legal phenomena? Taking into account the changes that are occurring, we must have a number of important points. Now, one of them, and here I partly disagree with Professor Cassese, and I come to my own field, comparative constitutional law. I'm so proud of it because I graduated in law in '75 with a thesis in comparative constitutional law. So I can say that I have been a comparative constitutional lawyer throughout my life. Now, there is somebody, even a very authoritative scientific scholar in the United States, speaking of world constitutionalism. And I don't like to speak of world constitutionalism because it does convey the idea that there is a constitutionalism that is present, operating, and perhaps effective all over the world. I prefer to speak of the world constitutional phenomenon. That means a worldwide expansion of the practice of adopting a constitution. We can't help assuming that consequently the meaning of key words and concepts such as constitution and constitutionalism cannot continue to refer to their original understanding necessarily related to the early European and North American experiences since the late 18th century. The deliberate choice on my part of the phrase world constitutional phenomenon instead of others such as world constitutionalism means employing a neutral, objective, value-free acknowledgement that most countries in the world have adopted a document which roughly describes the polity, lists the institutions that act on behalf of its government, spells out a number of expectations, not rights, expectations that citizens supposedly have on what those institutions of government are to do or not to do that will affect their freedom and welfare. Now, on the one hand, we have to acknowledge that we cannot continue with the Eurocentric or Euro-Atlantic centrism in looking at phenomenon, but at the same time, we don't have, for respecting global law, attribute qualifications that belong to our own historical experiences. And as a consequence, I don't think that you can speak of constitutionalism or constitutions without some further qualification. So we should speak of European constitutionalism, Asian constitutionalism, or we can have an ideological connotation, socialist constitutionalism, liberal constitutionalism, and this will accommodate also this quite, I would say, unhealthy practice of using for qualification some oxymorons like illiberal democracy or undemocratic constitutions. In other words, adopting the world as the proper setting for the comparative analysis of the constitutional phenomenon highlights a twofold reality. The first, space-wise, is that the concept of a written constitution establishing a polity and its government has widely circulated around the globe. And the second, time-wise, is that a written constitution is a modern functional equivalent of the normative and political ordering principle through which polities and their government have always been established and managed. So, this is just a small example of how the global legal environment, perhaps not an order, are affecting the way you conduct scientific research, which of course affects how you teach and affects how a law school is organized. So what do we learn from this? And what do we learn from the TLP experience? Now, I think that the law school must identify its mission, how to interpret its role in the global era, and how to perform its mission. Going beyond the generic law school if you want to be competitive and attract the best students, which is at the moment, happily, the experience of Trento. So this is a tribute to you, who are, I suppose, among the best students that we might attract. Now, this is not just a choice of today or yesterday. Trento Law School was established in 1984. It was, I think, the 41st or 42nd law school in Italy, and I don't think there was a need for a further law school. This was a law school that started with its own cultural manifesto, the Thesis of Trento. If you go to the guidebook of the law school, at the end you will find the Thesis of Trento, which is a cultural manifesto written by leading comparative law scholars, headed by Rodolfo Sacco. Its emphasis being on comparative method and on non-state law. That's also what Sabino Cassese said, transnational as non-state law. And mind you that in this law school, since the 80s of the last century, we had the transnational law study track, which we continue now, starting from comparative legal systems, which I think is the root of comparative law, and ending up to comparative religious law. And I'm very proud of this course because, as you understand, comparative religious law has nothing to do with state law. Such steps are important both at graduate or undergraduate legal education, and I would say paradoxically, at undergraduate level, you need to give and to receive, on the side of students, a wider range of intellectual tools and suggestions that would enable you to pursue one or another professional path. So from this point of view, the difference between graduate legal education in Washington University and in Europe is quite healthy, I would say. I have been last year a guest of Shenzhen Transnational Law School, and I was, of course, very curious to see how in China a transnational law school is organized. Now, apart from the very generous welcome and apart from the perfect environment and the good mixture of Chinese and non-Chinese scholars, I found out that the transnational law school teaches Chinese law and US law. Now, that's not my own idea of a transnational law school. So from this point of view, perhaps our two universities, our four universities are doing more, even though we don't have the ambitious name of transnational law school. What a law school can do by itself and what it can do by and through cooperation, synergies, and networking. And this is what TLP is a network of law schools that have been decided what their identity, what their mission was, and that have chosen a very ambitious and competitive path. Consequently, I would say that we did what I think most law schools must or should do, which means recruiting the teaching staff required for such a mission, for achieving the goal of materializing that teaching mission. And that's not very easy. You see, don't forget, and I'm referring to the students, I'm quite sure you will share my view. I remember participating to the foundation meeting of the International Association of Law Schools. It was very interesting from the cultural point of view. It was also very pleasant because it was in Oahu, Hawaii, just out of Honolulu. Most participants were from the US, but there were also many Europeans, a few Africans, Latin American, and the like. Now, we all agreed that in the global era, you need to teach public international law, which is not the case in many American law schools, private international law, and comparative law. And we were all convinced about it. But we all had one difficulty. Perhaps I was the one having the least difficulty. The difficulty was we all agree here, but then we go back to our law schools and all our colleagues will not understand, will not share, will be against investing money in international public law, international private law, and comparative law. So this is something which has been done, and I would say it's the law school that must find its mission first and recruit professors. I understand that if the existing teacher staff decides what the mission is, then perhaps the same process cannot be accomplished. So how to prepare the transnational law professor once you have a transnational law school? Of course, it is different from the European integrated law professor I spoke about 30 years ago. because it is not only a matter of individual study and research. I would say that preparing a transnational law professor is a matter of personal and institutional investment. You must put money into preparing a global law professor. Now, this may be cynical, but I would say it is realistic. You need more sabbatical leaves. You need better salaries. You need the possibility of internships in law firms and professional or international organizations. You need more opportunities for workshops with professionals, because we have to admit, at least this is my understanding, that practice is ahead of theory. Global law, the global law environment is more the product of practice than of theory, so that law professors must understand what is taking place and try to give some orderly understanding. Plus, let me add that we should have a global law school that is more than an Anglophone law school. Of course, English is the lingua franca, and I have nothing against it. But in particular in continental Europe, where so many of our students go to different countries with different languages, when they come back, they should be able to continue practicing their German, their Spanish, their French, perhaps their Portuguese. I don't mean all the languages of Europe. 23 languages are absolutely unmanageable, but at least the main languages are. Also, don't forget that we need these also for comparative purposes within the civil law world. The common law world is always in English, whether it is South Africa, Australia, United States, it's always English. Whereas the civil law has Latin languages, German languages, Slavic language, even Chinese. The Chinese pretend that they have a civil law system. Perhaps they have, I don't think so, but they pretend so. So that the Chinese language is also instrumental to a civil law system such as the one in China. And as anybody in comparative law knows, when you have so many languages, you must be able to read comparatively the language. So you must have some training in languages. And here again, I refer to Elena Ioriati for what she's doing in this field. So I think we did well. We shall continue to do well. We should do better. And this is the commitment for the forthcoming years. Thank you very much.
Right. Well, with disintegration going on at an institutional level, we see that economic integration and integration at other areas continues. And to give but one example, soybeans. There has been a trade war between the United States and China about soybeans. And so there are now import duties on the import of soybeans in the United States. And to compensate farmers for that, farmers get subsidies. As a result, European factories now buy extremely cheap soybeans from American producers. And at the same time, allowing the European Commission to say to President Trump, look, you wanted us to buy more soybeans, we do it. The only reason is they are extremely cheap, and basically we are benefiting from American subsidies. And that is how the global economy works. And that will not change, that will only become stronger. And that is where we need global lawyers. Right. Then our final speaker is my colleague from Utrecht, and it's a pleasure to have met him for the first time today personally. And it was very enjoyable.
We are very far away.
You are the director of UGlobe, a professor of internal market and fundamental rights. And you're going to talk about the T-shaped lawyer. Is that the T-shaped lawyer?
That is approximately the T-shaped lawyer.
Right.
Yes. Thank you very much, Chef. And thank you, of course, Elena, for having invited me again. And thank you for your patience to be still here. I always thought that in Italy you do not dine before 9 o'clock. So I understood from Chef that I have now 4 hours to talk.
But that is a
Go
mistake.
test your patience, of course. No, I will keep it short because I know I have been a student myself before as well, so I know your feelings. So thank you again very much for the invitation. I have not been involved in the Transnational Law Program, so I'm really an outsider. I'm going to give a little bit an outside perspective as well. My colleagues from University College Utrecht, they are involved in the Transnational Law Program, which is a bit strange, because University College Utrecht is a more multidisciplinary, you could say, bachelor education, although there are students following a major in law. So it's more liberal arts and sciences. So I'm going to give a perspective now actually beyond the law, so T-shaped lawyer, but also beyond the law. I could also talk about sports because I'm really happy that my favorite football club, Ajax, after 13 years, is through to the second round of the Champions League. I mean, this is really a celebration. So yesterday I dined with Elena and I said, well, I have to have a lot of wine. Because I really have to celebrate. This is my favorite club and I'm also a member of Ajax. So I'm extremely happy to be here, but even more happy that Ajax went to the second round. I have to be honest. So I will keep it brief. I have a number of slides. First of all, multidisciplinary research and education, a little bit of background, because is that also new? It's a hype, you could say, to do, of course, multidisciplinary research and education. I think it's very important, but is it very new? Because this pictures the Vitruvian man, so we can find actually quite a number of examples in the past of multidisciplinary researchers and also of education. And I'm currently reading, and that's true, it's actually next to my bed, Walter Isaacson's biography of Leonardo da Vinci. It's a very thick book, but beautifully illustrated. And Leonardo da Vinci's ability, as Isaacson writes, to stand at the crossroads of the humanities and the sciences is made iconic by this drawing of the Vitruvian man, and it made him also a creative genius of history. Now, according to Isaacson, although we might never be able to meet Leonardo da Vinci's talents, we can learn from him and try to become a little more like him. Be curious, be relentlessly curious, retain a childlike sense of wonder, get distracted. I don't hope you are distracted now, but you are allowed to do that. Think visually, avoid silos, and collaborate. I think that's a good starting point for multidisciplinary research. This is another figure, going back even more in history. This is Cicero, picture of a statue of Cicero, because also the Roman lawyer, so now I'm turning into towards the legal field, was broadly educated. And much broader perhaps than compared to today. And that started literally from the cradle, you could say, where ethics and philosophy were very important. So, which were then later on also important topics in the education of Roman lawyers. And furthermore, also a kind of politeness that you were learned. So broader than just purely legal techniques, legal instruments, legal skills. And I think if you now look at current practice, legal practice, then a modern lawyer of nowadays would perhaps feel quite at home in ancient Rome at the time, precisely because already they were taught these broader skills. Now turning to the T-shaped lawyer, and here, Chef, we have the T. Because that has now become a very prominent topic in the debate in law schools and also in legal practice. And the idea is of the T-shaped lawyer, actually it's borrowed from a broader concept, generally the T-shaped competence it is talked about, so it applies to more than just the legal discipline. But with respect to the T-shaped lawyer, a T-shaped lawyer has in-depth knowledge of one discipline, and that is the vertical stroke of the T, and it is also a breadth of knowledge across various disciplines, and that is the horizontal stroke of the T, which provides the T-shaped lawyer with the capacity to collaborate. So that's basically what we are talking about. Now, my colleague, Professor Elaine Mack, she had her, and she's one of the three sisters, Mack, probably Chef knows, Vanessa, I guess, at Tilburg University. There are actually three identical sisters. I don't know, how do you call that in English? You have twins and you have triplets. There are triplets, and you really cannot distinguish them. Well, I know now who is Chantal, who is Vanessa, who is Elaine, but they look very identical, and they are both, or they are all the three are professors in law, one in Utrecht, one in Amsterdam, one in Tilburg, and also the father was a lawyer. Well, this is, I've never come across that, but this is the side information. Well, she held her inaugural speech at Utrecht University, and she argued that contemporary legal education should encompass three main elements. First of all, differentiation, allowing for generalists, specialists, and indeed multi- or interdisciplinary legal professionals. Secondly, Bildung to develop a critical legal view on legal professionals' role. And thirdly, training aimed at handling professional ethical dilemmas. So ethics also plays an important role. Now, more concretely, she argues that students should have the choice to deepen their knowledge with respect, for example, to developments in the field of digitalization, in the field of globalization, because this is crucial in cases like we had in the Netherlands the Urgenda case on climate change. You see increasingly lawyers in Europe as well, which is maybe more common in the United States, to turn to the courts in order to claim certain rights in the field of the environment. And we are also going to have test cases in the Netherlands, probably, when it comes to prices of medicines, which are very high. We had a reportage on Dutch television a month ago, approximately a month or 2 months ago, about the pharmaceutical industry and the extremely high prices of medicine, which actually is not at all necessary. So now there's a foundation, and which is led actually by a lawyer, and they try to initiate court proceedings, see where that leads to. So you need lawyers who understand these problems, who understand these global challenges. But of course we also need the classical lawyer that is involved in a criminal case in a particular city or region in a particular country. So you need both. And that is of course the challenge. These kind of old and new aspects of legal professionalism, they come together in this T-shaped lawyer. Now, very briefly, what are then these European and global challenges that Elaine Mack is also talking about, and that, of course, Professor Cassese was also talking about, and in a way, Professor Toniati as well. So what are these European and global challenges that we are dealing with? Now, here I have a number of pictures. The one that I like most, but that's because I made it, more or less. That is Aristotle's face on a robot. Because we had a discussion in Utrecht during a conference about artificial intelligence and how far have we actually become in the field of artificial intelligence, and what does that mean for our global or our national, global, European legal order. Now, we have huge challenges in the world. We have challenges which relate to the global distribution of natural resources, space and food, and related to this, we have challenges creating an increasing sense of insecurity. And that actually relates, you could say, to an increasing sense of insecurity when it comes to identity problems. In a way, Professor Cassese also referred to that. And the situation in the world is rather paradoxical, you could say. Globalization and the worldwide problems that we face actually require a more international approach, and this approach particularly led by open and outward-looking societies. And the European Union is an example of that, with its more normative principles of an open society based on the rule of law. Article 2, Professor Cassese referred to that, and also the respect for human rights. So the European Union could play an instrumental role in this globalization process, which is undoubtedly taking place. Yet, on the other hand, we see that precisely those institutions are under increasing pressure, as also has been explained. And as a result, probably, of the unequal distribution of these natural resources, food and space. Think about the fact that a recent report that I saw, that the richest 1% of the world own half of the world's wealth. That is the reality today. So we have 1% of the richest people of the world that owns half of the world's wealth. That is the situation, and that is only increasing inequality. So no wonder that people feel increasingly alienated with the institutions that we have created, that cannot find a response to this. Now, and here I have a number of examples, of course, of those global challenges. Now, how do we try in Utrecht as a university to respond to that? And the response is indeed an endeavor for a more multidisciplinary education, and we as a law school are involved in this as well, because we recently set up a new center, a Center for Global Challenges, that is a cooperation between the faculties of humanities, on the one hand, and the faculty of law, economics and governance, because we are within one faculty. We have a law school, but we are part of the faculty of law, economics and governance. And the central theme of this center is to focus on this contested global order alongside, you could say, 4 domains: conflict and security, human rights, sustainability, and development and equity. And the 3 pillars that the center rests upon are research, global studies, and societal impact. And they are very much interrelated to each other. Now, you can, I'm not going to do that because of time, you can look up the website, maybe the slides will be made available to you, and there you can find all kinds of information regarding this center. I happen to be still the academic director of this center, which is in itself, I can tell you, a challenge, not just because you are a director of a certain center. I mean, there's so many professors, directors of centers, but precisely because of this multidisciplinary cooperation and the different cultures that exist within one university and between different faculties. I don't think Utrecht is different in that sense from Trento or any other university, or the Washington University of St. Louis. So I think we see that. Now, we try, you could say, by having established this center, to give effect to this T-shaped competency approach. And how do we do that? First of all, very simple, we cooperate between the international master programs. And these are master programs from both faculties. So European law, but also European governance, which is then, okay, part of the same faculty, but these are the governance people and not the law. But then we have, for example, conflict studies and human rights, which is a master program from the humanities faculty. So we cooperate under the umbrella of the Global Studies program, and there we organize seminars, master classes, a summer school for students, various events. Now we have also set up, and that's very new, a Global Studies certificate program. And there we select students who want to be involved, of course, in this program, and they can obtain a certificate, to do community work, precisely on areas which are global, because after all we are a Global Studies program, but they are translated into, actually, you could say, work which is also very relevant for a community. So Utrecht, as a municipality, underlines or underscores the Sustainable Development Goals. And there are all kinds of initiatives taken, adopted within the city, for example, for environmental reasons, together with the citizens of Utrecht. Their students from these programs are involved. They are working on these projects. They are talking with the citizens of Utrecht itself. They're going to the municipality hall, and then they write a report, a paper, which they present for us. So this is, in a way, trying to bring in, you could say, the horizontal stroke of the team. So they have already their bachelor program in law, in one of the legal disciplines, but then they look beyond that by, for example, being involved in these kind of programs or being involved in these events. Now, we even try to go further than that by developing an advanced master in comparative global perspectives, and then to adopt a shield-shape competency. I have not invented this competency approach, and that it means, so next you could say to the vertical stroke, we have two other vertical strokes. So students do right from the start, you could say, not only have skills in their own discipline, are trained within their own discipline, but also in other disciplines. But we try to do that by setting up smaller groups where they collaborate with each other. Now, other multidisciplinary programs that exist is, for example, the recently set up PPE Bachelor, which is Philosophy, Politics and Economics. It's the well-known Oxford-Cambridge model, which is now very popular also in the Netherlands. And then, of course, we have the University College Utrecht. Now, back to our law school, because after all, you are law students. So we have to, so this is about multidisciplinary cooperation, but how do we do that within our law school? If we look at research, then you could say there's a kind of trinity, the Holy Trinity, the Father and the Son and the Holy Spirit, you could say. And we try to translate that by having monodisciplinary research, so in your own legal field, like European law for me, for example, or civil law. Then we have multidimensional research, which is crucial because we cooperate with civil law, constitutional law, administrative law within research programs. Funding is distributed through these research programs. Then, of course, what I already talked about is multidisciplinary, beyond our faculty, beyond our School of Law, and the Center for Global Challenges is an example, kind of platform through which we can attain that. Now, multidimensional, monodisciplinary, this is of course the focus of our School of Law, but also of our students, because we involve our students right away. From the bachelor it's more difficult, especially in the master programs, in our research. And so last week we had a conference of organized by one of the research programs, and the students were also participating in that conference. There are challenges. Because if we look at education, this is research, but purely at education, what remains very important for the students in Dutch law is to obtain their effectus civilis in order to be able to practice as a lawyer. And so in university college students, for example, the Dutch ones, they find it a very nice education, but in the end, after the bachelor's, you say, oh, but maybe actually I like the legal part of that education very much. Maybe I should obtain a law degree, because after all, I want to become a lawyer. Yeah, then you have to have the effectus civilis. So you have to meet certain requirements, and that's the same for all universities across Europe. What we now try to do, and there's extra government funding made available, I just heard it actually last week, that we try to bring in more the empirical part in our legal studies. And that is not very strange, because after all, law cannot be studied in isolation from its societal context. So also empirical legal studies are very relevant. Now in Utrecht we say research-informed education is crucial. I had actually a Skype meeting just before I came here, and I was also questioned about this research-informed education. Well, Siba, how can we actually do that in practice? And I say, well, we do that in practice by involving the students in our research. Or when I give a lecture to, 800 first year bachelor students in Utrecht, I think we have now 850, so not everyone can be in the lecture hall. That is the disadvantage of such a big university. Then I try to talk also about my research projects in a way that might perhaps be attractive as well. So try to involve research in the education. Now, my final observations. It is, of course, a challenge. There are global challenges, there are European challenges, but there's also challenges to create a T-shaped lawyer and even beyond. Because how can we combine, you could say, these multidimensional, multidisciplinary approaches? How can we keep sort of the balance? How can we preserve at the same time high quality legal education? How can we realize a not one size fits all education? Because you want to address the classic lawyer involved in a criminal case in a town in Italy, but you also want to address the lawyers that are going to deal with the global and European challenges that need, for example, simply more knowledge about what is happening in the field of digitalization or technological innovation, because otherwise we can't simply take up the case. How can you combine that in your legal education? I think this is a huge challenge, also in terms of, for example, workload for us, the personal, the teachers having to teach this. What is the aim of eventually establishing a truly multidisciplinary approach? What do you, or what can you become after, for example, you did an advanced master in comparative global perspectives? What are they going to do, these students? Well, we think maybe it is for a particular group of students that are interested to lead multinational corporations, that know more about intercultural, you could say, cooperation. But not maybe the lawyer that is going to plead cases here in Trento, or in Utrecht for that matter. So we have to think about that as well. So after all, it is all about finding an optimal mix. Well, here I have the slogan of our faculty: we train people who want to take responsibility for shaping a dynamic, resilient and adaptable society. I think I put it on here. I didn't want to make some kind of promotional speech for Utrecht University, so don't misunderstand me. I'm just, giving the facts about what we are doing. Thank you very much.
Right, well thank you, Siva, and explaining exactly what the T-shaped lawyer is about. I think a difficulty that now faculties in the Netherlands now encounter is that we all see how to change the program, that there's a need to change the program. The difficulty is to convince the Bar Association and the judiciary that we actually still train and educate lawyers, but a different type of lawyer. Yeah. And there I think all of us encounter serious problems. Okay. Yeah. Well, thank you anyway.
I agree with you. Yeah, definitely.
Right. The final word is to, can I say, well, I was quite formal in my presentation, but can I say Elena? So the final word is to you, the person who is, in fact, is behind this program. I can say that, right?
Absolutely. She is the program.
You are the program. So the floor is yours.
Thank you. I'm not supposed to do the conclusion because I was supposed to do the introduction. So I don't know whether this is working the other way, but it was just because my idea was that of thanking some specific person who have been working in Transnational Law Program and underline that the Transnational Program is not me, but particularly I wanted to thank Roberto Tognatti because this was my introduction. When the Transnational Program was imagined in 2005, Roberto Tognatti was dean. And at that time, he asked me to participate in the first meeting at Utrecht University. When I arrived there, I found myself in a meeting with all deans. And I was really terrified. And I called Roberto Tognatti and I said, I think you made a mistake. And he told me, girl, the only way I have to understand if you can swim is that of throwing you into the water. And that was Roberto Tognati at that time. And I'm really, really grateful to him because the Transnational Law Program was part of my legal education. I really grew up learning, and I was really, really terrified at the beginning. But now I'm happy that everything ended in the, well, in a good way, let's say. Just a few words, because at that time, the idea we were discussing, the idea was the idea of Tom Schwartz, who submitted this idea to Roberto Tognati. And at that time, Roberto was, had written a very, very interesting article on the global lawyer. And I remember that we were discussing the way in which this transnational legal education had to be enforced. And I remember that we used to use the word ghost jurist, because at that time this figure was not really visible, that of the global lawyer, because this profile was not really clearly shaped. And so at the very beginning we decided that this legal education, that the Faculty of Law had to meet this challenge anyway, and so we decided to create this program which was based on the education of the jurists in both legal systems. But now I think that the situation has been evolving in the meantime, and that what we used to call a ghost jurist is now turned into a series of new figures and opportunity for law graduates and for you as a student. And I would like just to give you an example. When I teach to you, I teach to a group of students who are enrolled in the traditional 5 years program, but they are learning in English comparative legal system. And then the other group, learning in English comparative legal system, is enrolled in a 3 years bachelor program. And these two groups of students are really different. And when a prominent example is that when I use in class the term case law, for the 5 year student, this concept is on instinct. It means judicial opinion. But when I use this word with a 3 years bachelor program, the meaning is rule even not enacted. So it means that the situation is the same, the teaching is the same, the teacher is the same, and the language, but the environment in which you are involved is different. And finally, a third example, when I teach to the Italian student, comparative legal system, sistemi giuridici comparati, in Italian, the situation is different. Again, once more, because when I use the word giurisprudenza, that is case law, the meaning is interpretazione non fonte del diritto, so interpretation, this is not sources of the law. So this means that something is going on, because even if we use the same language and we teach with the same program, the result is different. And so I think that in this context, we are probably challenging a new frontier of legal education, and probably we should rethink part of our teaching program. So I would like to conclude here by thanking of course, the speakers. Thank you very much for being present and for your very interesting contribution. But I also would like to seize this opportunity to thank all the people who were involved in the Transnational Law Program. So Roberto Tognati as the dean, but also Luca Nogler, who was dean at that time, supported me a lot. And Giuseppe Nesi was so enthusiastic about the program that he used it as a model. And so is now activating, the faculty is now activating new program on the basis of the Transnational Law Program. I would like to thank the colleague Nicola Lugaresi and Martina Franceschi, Lorenza Zuccatti, Grazia Callovini, who are the supporter from the administrative point of view, and particularly the 50 TLP students who have completed the program, and the students who are present here, and who are the real protagonists of the Transnational Law Program adventure. So thank you very much to you all.